Welcome to the environmental law episode of the Williams Mullen Manufacturing Edge, a video series addressing key topics affecting manufacturers. I'm Liz Williamson. I'm a partner at Williams Mullen in the Richmond, Virginia office. I'm joined by Ryan Trail. He is also a partner and he's with our Columbia, South Carolina office. We help manufacturers in all aspects of environmental media. So without further ado, buckle up. We're going to try to hit 10 minutes as close as we can to give you your environmental digest of the day. So we picked enforcement because that is one of the top topics that we hear manufacturers ask us about. So I will turn this over to Ryan to get us started.
Thanks, Liz. So we're about a year into a new presidential administration, and you would expect a number of changes at the federal level and at the state level as far as environmental enforcement. Liz, what have you seen at the federal level and in Virginia with this new administration as far as enforcement trends?
Absolutely. So on the federal level, we have heard a lot of discussion about increased enforcement. As you all might remember, with the Trump administration, there was a lot more of cooperation with the states and pushing federal enforcement down more to the states. It was the cooperative federalism type topic. But now we're seeing that shift back and an uptick of the federal authorities partnering with the states to pursue enforcement. Environmental justice is also a common topic we're seeing in federal enforcement discussions. And so we expect to see that as things go forward in 2022. As for Virginia, we have a brand new development. We have an enforcement manual in Virginia, which is our guidance that really lays out the framework for enforcement in Virginia. That has been revised. And so it is now out for public comment as a document that people can look at. And that document shows us that they want to increase penalties. They have an inflation increase for enforcement. So what are you seeing, Ryan, in South Carolina, in your neck of the woods?
Yeah, generally the same types of trends. So overall, there has been an increase in focus on environmental justice, but overall there's an increase in the volume, the total number of enforcement actions that we've seen out of the state environmental agency here, DHEC. And associated with those enforcement actions, we've seen higher levels of penalties. So you mentioned the inflation increase. We've definitely seen that trend in South Carolina as well. So moving on, we wanted to share with y'all a couple of practical enforcement scenarios that we've dealt with for clients of ours in environmental settings. The first situation we wanted to discuss involved a client who had a permit to discharge industrial wastewater to their local publicly owned treatment works, or POTW. And this client received an NOV, a notice of violation, that was based on a single exceedance of a parameter in their permit. And the first thought, the initial reaction of the client is, we just need to pay this penalty and move on. We don't need to worry about challenging this or thinking about it more than we want to. We don't want to go to the trouble of appealing it. It's not a huge penalty. But one thing that we wanted to help the client with was understanding the importance of maintaining a positive and a clean compliance history. So if you've got prior violations on your record, it can lead to increased penalties in future enforcement actions, designation of significant noncompliance, which is not a designation you want on your record, and even revocation of your permit. So when a client receives a notice of violation, not just in the wastewater context, but really in any environmental media, you want to consider whether there are any viable defenses and look at whether it may be worth challenging that NOV, even if it's a small penalty. So in this case, we took a look at the discharge monitoring report, the DMR, that was submitted to the POTW, and we realized that there had been a laboratory error. and that the number that the NOV was based on was actually an invalid data point. The lab had not made the client aware of this. They messed up on their laboratory methodology, didn't follow the EPA methodology for analyzing the sample, which should have rendered that data point invalid, and the lab shouldn't have reported it at all. But they did. And the problem here is that under the law, once that report is submitted to the POTW, the data is submitted, it's presumed to be correct and accurate. And overcoming that presumption is a very difficult task. It wouldn't be enough for the client to say, one of our employees made a mistake in gathering the sample, or we packaged it wrong and reported it incorrectly. By showing conclusively that there was a laboratory error, so you got to use affidavits from the lab themselves. The personnel have to discuss the error that was made on the laboratory's behalf. And by doing that, we were able to show that the enforcement action really had no merit at all because it was based on bad data. So in this case, it was really worth the client taking a second look at what seemed to be a minor violation, and rather than just paying the penalty, by really digging into the facts of the case, they were able to find a way to maintain that clean compliance history and to avoid that violation. So that's one scenario that we've dealt with. It's brings up a couple of points that manufacturers will want to think about if they face enforcement. How about you, Liz? What have you seen?
Yeah, your scenario brings up a great point because it is so true here in Virginia, which is, gosh, sometimes it's so easy to just pay the penalty and move on. You don't have to hire a lawyer, get a consultant on board, and deal with it. But having that clean compliance record is so key as a significant penalty reduction mechanism when your state agency is looking at, okay, how much are we going to charge for that violation or a future violation? So I would just highlight that. I'm going to talk for a second about an air scenario, just to bring it on around to air. A little bit different, some of the same points though that you just brought up, Ryan. Had a manufacturing facility that they had been operating for a long time with an emission unit. It was permitted in their air permit. Then they said, well, wait a minute, we want to be good stewards of the environment. We're going to replace that emission unit with something that does the same job, but it actually had lower emissions. So lower emissions, right? They had an inspector come out as they did annual inspections. The inspector from the state saw the new emission unit. Everything seemed to be good. They're thinking, oh, we're doing a great job for the environment, right? Well, surprise, they get an NOV and it is a violation. That was because that emission unit was not in their permit. They still had the old emission unit in the permit. So I guess, thing one to think about is, just because that inspector is coming around and seeing what you're doing doesn't mean from an enforcement scenario, you're in great shape. So how do we try to get out of that jam? We had a great team together. We had the plant who had obviously a lot of history about what had been going on there. They worked with us as lawyers to look at exemptions and, look at all the avenues where we could potentially have an exemption. So maybe we didn't need to update that permit if it was exempt, that action was exempt. And then finally, there was a great consultant that recalculated, again, to your point, Ryan, about data, looking at the emissions coming out of that unit, because that was significant for some of these exemptions we were looking at. So it ended up to be a story where we managed to get the violations dismissed from that NOV. And the additional benefit is that there were some record keeping exemptions that were related. So of course, those dropped out as well. So it was a significant penalty reduction. Very happy that it happened, to work out. with, looking at the regulations, and that there was a way to get that penalty reduced. So I guess we kind of move into our final thoughts here in our 10 minutes. How can manufacturers pivot, put themselves in the best position possible in an enforcement situation? So I'll just give you my few points, and then Ryan, I know you have some thoughts in mind as well. I would say, again, dovetailing on my example, have annual or at least regular reviews of your plant personnel, looking at what is actually in your air permit, what you're actually doing at the facility, and making sure it all matches up. That will really tremendously help you in the long run to make sure it all matches up. And then finally, if you are in the unfortunate situation where you end up with a notice of violation, be ready to act quickly. That means have your team together, know who would be part of the team to try to address an enforcement scenario, who in part of your company would be in-house, ready to act quickly, who would be your out-of-house counsel, consultant, your outside resources. Because there are significant reductions you can see, at least in Virginia, that are actually written into our enforcement manual if you're cooperative and act quickly to call the state and address the enforcement issue. Brian, what about you? What are your top tips?
Yeah, so early, quick communication is key, like you said. If you're relying on outside consultants, you want to have an open dialogue with them about data that's being generated and being submitted to the permitting entity. You want to be in contact with your laboratory if it's a laboratory data that's being submitted throughout the process. You want to be in constant contact. And in the scenario that I discussed, it's very likely that early and open communication could have saved the client a lot of time and effort. So that's one thing. And then the other thing I mentioned in the scenario was that compliance history is really important. So if you're a manufacturer and you're faced with an NOV of any kind, of any size and substance, regardless of the level of the penalty, you should really consider whether there are any viable defenses and really do a cost-benefit analysis on whether you should simply pay that penalty or consider appealing it. So those are the two highlights that I would just give. And I think that wraps up our time here. So thank you, Liz. And thank you all for watching. If you have any questions, feel free to reach out to Liz or to me. You can also visit our environmental and natural resources and manufacturing web pages at www.williamsmullen.com. You'll find there a document that summarizes this video and other resources for manufacturers. So thank you for your time and have a great day.